afternoon, good evening. Welcome to the International Forensic Psychiatry Lecture Series, organized by the Forensic Psychiatry Program at McMaster University in St. Joseph's Healthcare, Hamilton. I'm Heather Molden, and I'll be hosting today's lecture. This innovative lecture series, Collaboration, presents 4 outstanding forensic psychiatry lectures each month. Lectures are organized as introductory, advanced, controversies, and global, and are designed to introduce top-notch presenters and topics to a wide audience. Registration is required, but it is free. Each lecture runs for 45 minutes, followed by a 15-minute Q&A session. Please use the Q&A function to ask questions. A schedule of future topics and speakers is available at www.forensic-psychiatry-institute.com. Registration is also now open for our annual Risk and Recovery Conference, which will be virtual this year. Please visit www.riskandrecoveryconference.com for more information and registration. And also, as a thank you for being an attendee of our lecture series, please enjoy a discount for that conference, and the discount code will be provided in the chat. As of now, there are about 500 registrants, and I want to thank all of you for attending today's lecture. I'm very pleased to introduce Dr. Al-Hamoud, who will be presenting on forensic psychiatry in Kuwait and the United Arab Emirates. Dr. Al-Hamoud is a consultant forensic psychiatrist. He's the head of the Forensic Psychiatry Department at the Kuwait Center for Mental Health. He's the founder and previous lead consultant forensic psychiatrist at Maudsley Health, Al Amal Psychiatric Hospital, Dubai, United Arab Emirates, part of South London and Maudsley. He's the president of Kuwait Psychiatric Association, and he volunteers occasionally with the nonprofit organization Médecins Sans Frontières, Doctors Without Borders. He was the chief psychiatrist working with the Parliament of Kuwait and the Ministry of Health on writing Kuwait mental health law that was recently passed in 2019. Dr. Al-Hamoud is Canadian board certified by the Royal College of Physicians and Surgeons of Canada in both forensic psychiatry and adult psychiatry. He graduated from the psychiatry and forensic psychiatry residency programs at the University of Toronto. He holds a master's of jurisprudence in health law from the University of Chicago School of Law. He earned his medical degree from the University College Dublin in Ireland. Please join me in welcoming Dr. Al-Hamoud.
Hello. I think you can hear me.
Yeah, we can.
Yeah, okay. Well, thank you, Heather, for the beautiful introduction. I'm actually honored to be present with you guys today, to be hosted. Among great names, I see that they've been presented and they presented in the past. Some of them, they were my supervisors and mentors when I was a resident at the University of Toronto. So it's really a great honor. Today I'm going to talk a little bit about the forensic psychiatry, the practice of forensic psychiatry in Kuwait and the United Arab Emirates. So mostly Kuwait, since I'm originally from here, and this is where I started practicing since I came back from Canada in 2016. So I'll share my screen with you. This is about the lecture. So I'll try to be as quick as possible. Try to finish this in 45 minutes. Of course, it's almost impossible. I mean, covering the whole forensic practice in Kuwait and the UAE. But it's going to be more as an introduction of what we do exactly in this region, and especially for people practicing in the West, And for me also, I mean, when I was practicing in Canada, then coming to Kuwait, which was interestingly a shocking experience. Everything was so new, but at the same time was a beautiful journey. So what I'll be talking about is a little bit historical background of mental health in Kuwait and the UAE, plus the forensic mental health in those countries. Forensic mental health services, specifically in Kuwait and the UAE. I'll try to analyze Kuwait mental health law and compare that with regional and international laws, especially Canadian laws. So briefly about Kuwait. Kuwait is a Muslim country situated in the Gulf Peninsula. Population is just over 4 million, and mostly the population are made of expats. So it's only a third of the population are Kuwaitis. It's a constitutional sovereign state with semi-democratic political system. There is actually a separation of powers in Kuwait, where the government, which is the executive power, the legislative is the parliament, and then the judicial, which is the court. It is a high-income economy, country backed by world's 6th largest oil reserves. There is a common misconception about the legal system in Kuwait and the region of the Gulf. A lot of people believe that the Gulf, they follow Sharia law. This is actually not true, except mainly for Saudi Arabia, but the rest of the countries here, actually, they follow civil law system. And this is mostly modeled by the French legal system, and it's really adopted from Egyptian laws. Which usually, most of it uses the civil law that is based on the French law. The criminal law, however, in the region is using the British law. So the Sharia law, we do of course use Sharia law, but this is mostly for family law and mostly for Muslims, but non-Muslims also, they can use a secular family law. In the legal system in general in the Gulf countries, and this is what's called the GCC, this is the Gulf Council, it's usually uses the same type of laws. So in reality, when I'm speaking about the forensic system in Kuwait and the UAE, it's going to be almost the same in all countries, maybe except for Saudi Arabia, because they use the Sharia law mostly, which is not a secular type of law. And as I said, it's mostly adopted from the Egyptian laws. In reality, actually, specifically, there was one person or group of people who made most of the laws in this region. And a very famous Egyptian scholar who was a judge and an academic by the name of Senhuri. He actually not just he made the laws of the Gulf, but even for Iraq and Syria. So a little bit about the mental health in Kuwait. In Kuwait, there is only one psychiatric hospital that was built in '58, and this is Kuwait Center for Mental Health. It's actually huge. It's one of the biggest psychiatric hospitals in the region, with almost 700 beds, and receives more than 6,000 patients a month from all the country's provinces, which are 6 provinces. So those are pictures of the center itself, and here there's the picture during the mental health day and the celebration with the staff and patients. A little bit about the forensic mental health services in Kuwait, and specifically in the hospital, the Kuwait Center for Mental Health. The forensic services were established in 1981, and the unit itself, or the department itself, occupies 2 wards with 36 inpatient beds divided between assessment and detention. The cases referred for assessment divided into criminal and civil. Majority of the criminal cases seen, they usually come for criminal responsibility or asking for violence for risk assessments, and mostly they come from the court, public prosecutor office, or sometimes even from the police. Interestingly, the practice in Kuwait and the region also is a little bit different in the West, in in that we do see a lot of civil cases. This was very uncommon when I was practicing in Canada. So the big bulk of the cases that we see in forensic in Kuwait is actually civil, mostly in the form of financial capacity, form of custody capacity, testimonial capacity, for impairment and disability due to mental illness. And usually those cases, they come straight from the court. The court specifically asks for that, and then they ask for those cases to be referred to forensic psychiatry, to be seen by a forensic specialist. And one of the major differences also between the region here and the West is that the court also specifically asks for a committee or a board of experts, of psychiatrists to basically assess the patient, whether it's for a criminal case or for a civil case. So unlike, for example, when I was practicing in Canada, where only one psychiatrist, for example, for the Crown prosecutor, he assigned one psychiatrist, and the defendant assigned for one psychiatrist, and both of them, they go to the court. It's totally different in this region, where the court asks for a board, a committee, usually with odd numbers, but most commonly it is a number of 3 psychiatrists or more. The same thing was in what we did in Al Amal Hospital in Dubai. So when I joined them in 2019, I worked with them almost for 15 months. And the idea was to establish forensic mental health services in Dubai. And the same thing as in Kuwait, there was forensic mental health services, but in reality, most of the people working in that services, they did not follow any international guidelines. And you can imagine, so most of, for example, the cases that we're seeing in Kuwait, they didn't follow any test for the criminal responsibility. For example, they didn't know about the McMaster test. They didn't follow any specific test for the discharge of the patient. They didn't use any objective tools. So most of the assessments, they were done using only clinical judgment, which, of course, I mean, for any person who's specialized in forensic, this is really mostly equal to chance, and which is really, I mean, not the best type of assessments. So we did the same thing with when we joined the Moseley group. So the Moseley group are a British group. They're basically the same group from the South London and Moseley. Dubai, they made a contract with them to run and manage the hospital in Dubai. Which is in Dubai, that's the only psychiatric hospital also. And one of the services was basically the forensic psychiatry. So I had the honor to actually go and join them, and I was working as a lead forensic psychiatrist at that time. And we did establish the forensic mental health services back then. So we followed basically the same type of model that one we use in Kuwait, which is exactly basically the same type of model that we also use at the West countries of the region. So this is a little bit of diagram shows how the services are divided in Dubai, and also the same thing in Kuwait. So the services are divided into the inpatient, the outpatient. The community is still not running. Most of the problem happened because of the corona, so there was a huge delay with that. And interestingly, the difference is you can see that with the outpatient, is divided between 2 things: the OPD clinics, and this is, of course, I mean, the patients, they get discharged, or they get the conditional discharge, and then we see them. And also there's the medical boards, and this is quite different. So the medical boards are those boards that they oversee the civil cases, so mostly financial capacity cases, the custody, the malpractice, impairment, disability, and so on. Most of the region, the countries in this region, they are members of the WHO. I was representing Kuwait in a number of the meetings that we had between the Gulf countries. So there is a council between all the countries of the Gulf, where we meet annually and specifically talking about mental health. So there's a meeting for all different specialties in medicine. One of them is the meeting about mental health. And one of the requirements by the WHO is that they're saying all the members of the WHO, they need to have legislation, mental health legislation and policy by 2020. And interestingly, of course, if you go into their website in that WHO, that tells you that most of the members of the WHO, they do have a mental health policy or a plan, but in reality, actually, half, which is 50%, they do not have a mental health law. And this is not surprising. I was working in Kuwait since I came from Canada 2016 until 2019 without a mental health law. I mean, for a person who is used to working in a place where there is a mental health law, would be very surprising. Saying, how do you guys, practice without a mental health law? And I assure you, it's really not easy at all. So we depend mostly on the families to bring the patients when they are unwell, and also, to take them if they are well. But at the same time, there is also the belief that, yes, the region here, the Kuwait, for example, is a rich country where most of patients with mentally ill, they reside with their families, and part of that is true. But at the same time, also, a lot of those patients, they get neglected by their families. So what happens, they take a mental health hospital, a psychiatric hospital as shelter, which becomes very difficult to discharge a patient because we do not have boarding homes or mental health shelters for those patients, so they just stay in the hospital, and they do stay for years. So this is one of the meetings in 2000. This is the plan was 2015 to 2020. It is the GCC Mental Health Operational Plan. It does mention in the plan itself, so I tried to translate some of it, that by 2020, 100% of GCC countries should have mental health legislations. And it does say specifically that policies and legislations for the GCC countries should implement policies and legislation by 2020. Unfortunately, not all GCC countries have mental health laws. Some of the countries, they still don't have. I think also Corona was a part of that did delay. But most of the countries, they do have a draft of a mental health law. So what we did in 2016, so when I joined the hospital here in early 2016, and we started working without the mental health law and trying to basically compare what we were going through in Kuwait and when I was back in Canada using the mental health law in Canada. So we started thinking of a simple way of using, or basically, trying to use something just to protect us and protect the patients. So we decided for creating something, what we called it the RCB. So we said that not having a mental health law doesn't mean that we cannot be creative and start something that really protects the rights of the patients. So we did something that what we call the RCB, and this is a hybrid between the CCB, the Constant Capacity Board in Canada, and the ORB, the Ontario Review Board, or the Review Board, Tribunal Review Board for Forensic, also in Canada. So we made something which is a hybrid. We called it the Review and Capacity Board. It was not ideal. By the way, it's still functioning. So we made it to look like it's made of 3 consultant psychiatrists who are basically, it is an internal policy. So the 3 psychiatrists are from the same hospital in Kuwait, overlooking those patients who are involuntarily admitted, who are seen as being incapable regarding treatments, and also the forensic patients. So we were doing the annual hearing for the forensic patients to assess whether they need to be continue to be admitted or to be discharged. Of course, it's not ideal because it's not neutral. So it is still made of psychiatrists from the same institute or the same organization. However, it has to be from a different unit or different team. This is just a way, at least, to protect the rights of the patients, and also to share some of the responsibility of the treating doctors. Because in the past, without even having, before having even the RCB, it was only the treating team who were completely responsible for admitting the patient involuntarily, treating the patient against their will, and discharging the patient. The same thing also with forensic. So the patient is to be discharged from the forensic solely by the opinion of the treating team. And you can see the amount of responsibility the treating team goes under. Interestingly, the same model was adopted also in Al Amal Hospital, and we created the same thing, the RCB in Al Amal Hospital, which is actually still functioning very well in both in Kuwait and Al Amal Hospital. The reason why that the RCB is still functioning in Kuwait, because even though there is a mental health law, because the mental health law is still not active, and some of it is still being delayed because of the corona that happened. I'll tell you a little bit about that so it becomes more clear. As a big part of the mental health law, to apply it, to start applying it, there has to be a council, a mental health council, and still that mental health council is not formed yet because of the delay that happened with the corona. So when we started working on the RCB in 2017, and a lot of work also we started doing with a number of mental health campaigns in the country, in Kuwait. A number of mental health campaigns, one of them was called Mind Me, which is short for Mental Illness is Not Disabling Me, and Taqabbal, which is the Arabic word for accept me for having a mental illness. Interestingly, so those mental health campaigns, they worked very well, in which that we started meeting members of the parliament, politicians and all that, and raising the issue of mental health and the need for mental health law. And with a number of pressure that we started doing, we were actually very successful in making the parliament themselves, the members of the parliament, to adopt our cause and the draft that we were working on with the mental health law. And then with the collaboration between the parliament and the Ministry of Health, we were actually very successful in passing the law, which happened early 2019. This is a picture of all the team with that were working on the mental health law. Some of them are human rights organizations and members of the parliament. This is a picture of the mental health law itself, the Kuwait Mental Health Act 2019. I'll go briefly with some of the definitions and topics of the mental health law, just for you to have an understanding about the difference with the practice in the region in here and the West or other countries. I'm sure it's going to be of interest to all of you. The definition of mental illness, I think this is one of the most challenging things that we faced, is how to define a mental disorder or mental illness in a scientific way, but also at the same time trying to be respect the culture and the politics of the country. So the definition of mental disorder in the mental health law says that it is a psychological or organic brain condition resulting from a disturbance in the psychological or organic functions that affect the functioning of the person in his social environment, excluding alcohol or illicit substance abuse. This was one of the things that sometimes you needed to have a balance between politics and science. So we faced a huge resistance with the definition of drug abuse in general. I mean, of course, scientifically, there's no one denying that drug abuse is really a mental disorder. But at the same time, we face a huge opposition to include that under the definition of a mental disorder from a political point of view. So sometimes, this is one example where you need to have a balance between the push and pull, where sabotage the whole law for something, so you have to basically do some sacrifices. And interestingly, one of the other things that they wanted to exclude was actually personality disorders. Well, we did really oppose that strongly, and we succeeded in that. So interestingly, the review and capacity board that we started with an internal policy, we adapted that in the mental health law. So now we have that exactly, the review and capacity board, which is exactly the same hybrid of the CCB and the tribunal review board that Canadians who practice psychiatry are very familiar with. I'm going to a little bit talk about the civil part of the Mental Health Act before moving to talk about the criminal part, which is what's of interest to us today with the forensic lecture. So just a summary of the important sections of the mental health law that was passed. Just similar to most of mental health laws, of course, there has to be the period of assessment, which in Kuwait we did the 72 hours, similar to the one in Ontario. There is a criteria for involuntary assessment, and then there's a criteria for involuntary admission, which is, again, the same to most mental health laws. The risk to self, others, or substantial risk of deterioration mentally or physically. Involuntary admission, first is up to 2 weeks. There has to be the approval of the RCB. Then involuntary admission extended, so the first period is 2 weeks, then 1 month, then 3 months, then 6 months, and everyone has to be the approval of the RCB. After that, after 6 months, there has to be an approval of the council. So there is one mental health council that overlooks all different RCBs in the country. So after 6 months, there has to be an approval of the mental health council to accept and see whether the patient really needs to stay or not. By the way, we use basically the same model, that the onus is on the party raising the issue. So the onus is not on the patient to say that he is risk, or that he needs to stay, or that he is incapable. The onus is basically on the treating doctor himself. Okay? No treatment without consent except for emergency. So there has to be a consent. There's an RCB approval for treatment capacity. So also, if me as a treating doctor say the patient is incapable regarding treatment, I need to prove to the RCB that the patient is not capable, and not the opposite. Interestingly, so we made sure that we added in here that treatment can be given when an appeal process is happening, and we try to learn from one of the major cases in Canada, which is the Stars and Swayze case, in which that patient stayed in a mental health facility for more than 6 years without a treatment because he was capable, which is capacity is governed by a different law, which is the Healthcare Consent Act, and then the admission is governed by a different law, which is the mental health law. So we try to make sure not to have a similar problem in which we say that a treatment can be given during an appeal, because in Canada, for example, you cannot, I think mostly in Ontario, that you cannot treat a patient when there is an appeal in process. Of course, we added the community treatment orders, and what's different in the law in Kuwait, we mandated the government to build care homes for the mentally ill. And this is really important because, as I said, a number of patients, they are brought by the families, they are abandoned by the families in the psychiatric hospital, and then they're left for years. And the problem that in the country, we don't have boarding homes, we don't have shelters for mentally ill, so the patients are just staying in the hospital, which is honestly, I do believe, and we all do, that's very inhumane. So now with the law, we are actually mandating the government themselves, especially the Ministry of Health, to build nursing homes or care homes for the mentally ill. One of the interesting differences in the law and how we're trying to find a balance between a conservative society and, of course, using those type of laws, which are really Western in nature, and trying to strike that thin balance between the Western laws and the conservative society was Section 19. So the section says any patient can sign himself out after finishing his treatment, except if he is a minor or when there is a court order in place. So the age of consent in the law in Kuwait is 18. So above 18 is considered basically, any person who's above 18 is considered an adult. Anybody who is basically reading this section, especially if you're practicing the laws, they say, why do you even need to have a section like that in the law? Well, in reality, you do. Because what's been happening is that, for example, if you have a patient who is 18 years old and one day, even though he is able to consent for discharge, but at the same time, the family will not, for example, take him if they want to. Right? Especially, for example, for female patients and that, where, for example, the father of the family, they would give us sometimes a hard time saying, why did you discharge my daughter? And she's just 18 and 19 years old without my consent, right? Because, again, some of the conservative and cultural issues in the region. So we made sure to have a section about that, saying that the patient, if he's really not a minor, he can sign himself out, okay? But at the same time, even though, now we have this law and we are protected, we have to, of course, respect the culture. So we still involve, of course, the family in the care and the discharge of the patient when the patient finishes his treatment. Okay, so moving on into forensic mental health services in Kuwait and the UAE. This is now more specific about the forensic services. The first one would be the fitness to stand trial, and of course, if you practice in the West, the most common type of assessment you would do in forensic would be fitness to stand trial. However, if you practice in a region, this would be the least type of assessment, and I'll tell you about that. So the fitness stand trial, the law itself is, the test itself is found in the Kuwait Criminal Procedure Act. So I tried to translate some of the laws. Unfortunately, the laws are mostly in Arabic, and it's really difficult to find a correct translation of it. So the section 118 is translated into if the accused is found to be suffering from insanity or cognitive impairment or a disease of the mind that affects his ability to defend himself in court, the court must order for stay proceedings until the accused is able to defend himself. The court has the right to send the accused for treatment at a psychiatric facility or to any of his relatives for care. So we do have that section talking about fitness to stand a trial, and that if the patient is unfit, he needs to be admitted for treatment. The same thing also in the UAE and almost all the countries in the Gulf. By the way, I was only trying to speak about Kuwait and the UAE, not because there's any difference between the laws or the practice of the other countries. The practice is almost the same in all the countries of the Gulf, maybe except Saudi Arabia. But at the same time, I don't have that much experience because I didn't work in other countries other than Kuwait and the UAE. But currently, I am actually working with the guys in Qatar and Doha and doing some collaborative work. And I was reading the law of Qatar the other day, which is exactly the same as the one in Kuwait and Qatar. Unlike, for example, fitness stand trial in Canada, which is governed by the Section 2 of the Canada Criminal Act, in here the definition of fitness stand trial is there. It is well defined, and which is saying that in particular, fitness means unable on account of mental disorder to understand the nature of object of proceeding, understand possible consequences of the proceeding, or communicate with counsel. So it is well defined. However, in here in the region, fitness stand trial is not defined, so it's left to basically the committee or the experts, doctors, to define that. Criminal responsibility, and this is the main bulk of the criminal cases that we see in the country. Interestingly, criminal responsibility is not something new to it's not something new that we adopted from Western laws, but the concept was there even before we started using Western laws, in which in Hadith, which is the saying of the Prophet Muhammad, he did mention about the mens rea, and how patients who do not lack the mens rea they should not be responsible. And specifically, you say that the pen is lifted from 3 people: a sleeping person until he awakens, a child until he becomes an adult, and the insane until he regains his sanity. So it's basically the same thing talking about the mens rea. And interestingly, even other cultures, even before religions, Hammurabi spoke about the same thing. Of course, what made the modern test that we use even here in Kuwait, and I'm going to tell you a little bit about it, is the McNaughton's case, the McNaughton's test itself. And so McNaughton basically was a patient or a person who did suffer from delusions, and in 1843 he shot down the secretary of the Prime Minister. He mistook him as the Prime Minister himself. In which, so what happened is that the Parliament did put the rules of the McNaughton test, and the test was saying that the sanity is presumed, and then the test that we still use today when we assess criminal responsibility is that the patient has to have, 1, the disease of the mind, suffering from disease of the mind; 2, that he should not be able to know the nature and quality of the act, or is not being able to know the wrongness from rightness. And this is exactly the same definition that, for example, is used in the Canada Criminal Act. However, interestingly, comparing that with Kuwait's Criminal Act, for example, the same thing would be in the UAE. And here it says that no person is criminally responsible for an act committed or omission made where at the time of the act the person was incapable of appreciating the nature and quality of the act or omission, or of having capacity for rational choice due to a mental disorder or cognitive impairment or any other abnormal mental condition. So the same thing, we need to have a mental illness. 2, the patient should be unable to appreciate the nature and quality of the act. 3, or unable to have capacity for rational choice. This is, interestingly, the difference. If you see the criminal acts in Canada, for example, it says, or of knowing that it was wrong. In Kuwait, the UAE, and most of the region here, it says that when the patient was not able to have rational choice. But interestingly, when you, for example, examine some of the Supreme Courts of Canada ruling, for example, in the case of Uman, you would find that in capacity, the meaning of rightness or wrongness is exactly the same as when the patient is unable to have a capacity for rational choice, in which the case of Uman, the court said the accused is exempt from criminal responsibility, where at the time of the act, a mental disorder deprived him of the capacity for rational perception, hence rational choice about the rightness or wrongness of the act. So in reality, at the end of the day, the definition or the McNaughton test is exactly the same, whether you do that, for example, in Canada or in the region in here, which, of course, made our life much easier for us. Coming from Canada and practicing in here, so basically we use the same test. This is the test, the section about McNaughton test in the UAE Criminal Code, 1987, which is basically exactly the same thing. This is a study that we published in 2018. It's a retrospective case review about the patients who were admitted in the forensic psychiatry department in Kuwait for a whole year. Interestingly, so we did, of course, describe the practice in Kuwait, and we did say that the forensic psychiatry unit at department in Kuwait Center for Mental Health provides the only official forensic psychiatric services in the country. Patients detained at the FBU go through rigorous assessments before being released into the community. They are managed under the Kuwait Criminal Code, and our job basically is divided into the assessment and management of the patients. The Criminal Act of Kuwait is based on British legislations, as I was saying. So most of the criminal laws in the region, they are based on British legislations, and the sections concerning the criminal responsibility and the law itself is Section 22 and Section 23. So interestingly, this is the results that we came out from the study. I think it's going to be of interest to the audience in here, and to compare that, for example, to the ones in the West. So we examined 95 cases of NCR cases we reviewed. So interestingly, so 95 cases were seen in 1 year, which is equivalent to around 2 patients a week of NCR cases, of criminal responsibility cases, which is a little bit, if you think about it, is really high, because I mean most of the patients that we see are civil, as we were saying, and the civil cases are around maybe 10 to 15 cases a week. So on top of that, we have the criminal responsibility cases, which is around 2 a week. So honestly, the load is really big for a small population, which is 4 million. At the same time, what's interesting, that the majority of the cases we saw were actually Kuwaiti citizens. So the 2/3 of the cases were Kuwaiti citizens, even though the locals, the Kuwaitis, they only represent 1 million, 1/3 of the population. So the majority, 2/3 of the population, actually they're expats are not Kuwaitis, which really doesn't make sense. So what's really happening to the majority of the people? Are they being missed? They're not coming regularly to us. The court is not asking us to assess number of the patients. So I mean, still, to be honest, we don't know, and we have a number of theories behind that. And we said, of course, in what we found, which was similar to many of the Western countries, that, of course, I mean, the majority of the crimes are done by young men, 20 to 39. Most of them, they with low socioeconomic status or low education. Most of them, they were single, which is exactly the same criteria for of criminals in everywhere. The same thing, interestingly, was what we found, that the most common diagnosis that we found that we were seeing was substance use disorder, but the most common type of disorder that negate responsibility was psychosis, which is not surprising. What's interesting also, what we found is that 55% of the offenders were found to be criminally responsible. So 45% were NCR, which is quite high compared, for example, to in Canada. It's only 10% of the cases are seen to be, they were said to be NCR. Also, what's interesting is that most of the female patients that we saw, we found them actually to be not criminally responsible. And one theory behind that is that because of the conservative nature of the country, a lot of the cases of the charges against women, they get actually dropped, interestingly, except when it's really a serious charge, and there's very obvious mental illness involved, and then those are the cases that we get to see. So the conclusion of the study, that we say that we are very desperate, that was in 2018, we said we are very desperate for mental health law, and we needed also some changes of the criminal law itself. Specifically, we did say that there is no availability of conditional discharge, in which that the patient only comes in and then we ask the court to discharge him. So there is no conditional discharge. There's nothing in between. So how can you test someone in the community if you do not have the law that protects you, saying, or grants you to use conditional discharge? At the same time, the whole responsibility on discharging the patient and taking basically the decision to discharge the patient lies on the treating team. So there is no neutral tribunal board. And of course, I mean, you can see the amount of responsibility the treating team go under. So also the same thing, we said that the test for discharge was not clear, in which the test for discharge was saying that, and this is, you can see it in here, that it says, this is the continuation of the mental health law. This is the continuation of the section 22 of the criminal law. Say that when the patient is deemed not responsible, then the patient is to be admitted until the cause that resulted in the admission is lifted. So, but what is really the cause? So the courts usually, when they send the patients to us, they say, a patient is to be admitted until he is not a threat to the public or until he is cured. And this is really, I mean, the old definition of the cause, in which, and this is really not, I mean, constitutional, because in reality, I mean, mental illnesses are chronic, so we cannot expect them to be cured. So patients can be detained indefinitely. If we define it as until the illness is cured. So we asked in the paper that the definition should be really clarified. The cause itself should be clarified. The test for discharge should be more clarified into significant threat to the public rather than until the illness is cured. And this is, we explained the same thing in a letter to the editor that we published just recently in The Lancet. That was in November 2020, actually. We described also the flaws of the criminal law of Kuwait, in which there is only a test for admission, which is the McNaughton's test, but at the same time, we don't have a test for discharge, right? And we don't have the conditional discharge. And at the same time, also, we don't have a tribunal board that overlooks the matters of the patients who are being admitted in the forensic department. So at the same time, when we were working at the mental health law in 2019, we were thinking of, you know what, we have, if we want to change the way that the patients are admitted into the forensic, and then try to add those conditional discharge and try to add the definition in the criminal law, it's probably going to take years and years. I mean, just like the same thing that had happened in Canada, for example, with the Swain case. But why not, if we're working on the mental health law now, why not add a part that really governs also forensic psychiatry in the mental health law? And interestingly, we did that. So we added a section, so two sections, we add them in the mental health law that governs only forensic psychiatry, and I'm going to read them to you. So section 20 says, an accused shall be admitted to a psychiatric facility when an assessment order is issued by the court or the office of the public prosecutor. The mental health condition of the accused shall then be examined by a specialized medical board assigned by the Ministry of Health. And here, of course, I mean, we're asking specifically about specialized medical board because, again, this is what the courts usually do. They ask for a specialized medical board. This is the interesting part I want to share with you. So we added this section that basically, I mean, solved the issue of the forensic psychiatry in Kuwait. So we said that a patient who is found to be not criminally responsible due to mental illness shall be admitted by an order from the court to a psychiatric facility for treatment. The RCB shall be notified within 2 weeks for admission. The RCB shall review the admission annually or earlier if needed, and the patient shall be discharged after the recommendation of the treating team, the RCB, and the court when he is no longer a significant threat to the public. No conditional leaves are to be granted until after the approval of the RCB and the court. So we added an independent review board, and this is the RCB. So the RCB shall basically see the patient. Every patient is admitted to forensic, and also they're going to be responsible for the leaves. They're going to be responsible for the decision of the complete discharge. A test for discharge. We added that, so now it is really clear. It is no longer a significant threat to the public. And again, this is basically the same. We adopted that. I mean, we took the same idea from the Swain, in which before, well, the Swain, that's the famous Supreme Court of Canada case, in which that resulted in Bill C-30. And before that, the test was substantial recovery. And then that was basically changed into a significant threat to the public. And this is really, I mean, what should be. The test for discharge should be the threat to the public rather than the cure or the recovery of the patient. And then third is we added the conditional discharge. So this is no conditional leaves should be granted until the approval of the team, the RCB, and the court. And of course, a third one is a treatment. So specifically, we say that when the patient is admitted to forensic, he is admitted for treatment. And we're learning from the same problem that happened with Starson and Swayze, in which a patient stayed in a forensic facility for more than 6 years without treatment, was just taken PRN just because there is a difference between the treatment is governed by a different law than the law that governs the admission. Of course, I mean, this can be arguable that when we say that, I mean, a person is to be treated in forensic, of course, I mean, not every patient with NCR needs a treatment. Of course, I mean, if you have patients with dementia or intellectual disability, you might argue saying that those patients don't need treatment. But in reality, I mean, treatment includes everything, even psychological treatment, behavioral treatment, and so on. And with that, so that's basically in the conclusion that we were saying, and we were basically in the past, we were saying that there is no availability of conditional discharge, so we were able to add that, and we were saying that no availability of mutual review board, so we were able to add that in the mental health law. And at the same time, also the third thing, that when we said that the test for discharge is really not clear, when we wrote this paper in 2018, we were able to add that in the mental health law 1 year actually after that paper was published. And this is a picture of us, the team, a number of, those are the members of the parliament in here. This is the Minister of Health, and this is Dr. Adil Zaid, who is the director of the hospital, and this is the secretary of the parliament. And that was us working on the mental health law. With that, I'll leave you and open for questions and comments. Thank you.
Thank you so much, Dr. Al-Hamoud, for such an interesting talk today. And it's so heartening to hear about these exciting developments. And so thank you so much for sharing those with us. We have some questions, so I will have a look here and start to share them with you. So one of the first questions here is, how are domestic violence related cases dealt with? So using Sharia law or criminal law, and what's the role of forensic psychiatry in these cases, if any?
Yeah, interesting. So again, Sharia law only governs family law. So family law is more about the divorce, about marriage, inheritance, and that. But domestic violence itself, there is actually the government, they just signed a law just recently, I think also last year, about abuse to women, in which they created also shelters. They're mandating the government to build also shelters for women who are abused. So this is a completely different law, and it's all like civil law. To be honest, we rarely receive cases about that. I mean, most of the cases that we receive that relating to that would be custody, especially if it's brought by the child protection team. in which they witness, for example, an abuse to the kids. At the same time, they do, if they witness, for example, an abuse to the females, or the opposite, they would ask us whether, do you think that there is a mental illness involved? Do you think the partner is violent, or he is risk or not?
Okay, thank you. Thank you very much. One of the other questions that we have here is, how is a balance struck between political and medical points of view regarding drug dependence or substance dependence?
Sorry, can you repeat the question?
Sure, yeah. So it says, how do you proceed to find a balance between political and medical points of view regarding drug dependence? So sort of, the illegality of drug use versus sort of our medical understanding of addictions.
Yes. So, I mean, in reality, we do, of course, we do have an addiction center. It's specialized in the treatment of addiction. We do have all the facilities for that, for even for patients to be admitted and treated and so on. However, when I was talking about the definition, the legal definition of mental disorder, substance abuse was excluded from the definition itself for legal purposes. And the argument was from the MPs were mostly that we don't want patients with addiction to start getting to be NCR just because they committed a crime. Of course, we try to explain to them that this has nothing to do with given the designation of criminal responsibility, because under the law itself, under the criminal law in Kuwait, alcohol and drugs do not negate responsibility. But in reality, same thing. It becomes really challenging to try to convince them, and then that's when it comes to trying to find a balance between what you need to give and take, and whether you should sabotage the whole law or just accept some of what the politicians are asking for. So that was really the reason why we put that in the definition, that substance use is not considered mental health law. But in reality, we rarely use that. So treatment is basically given to patients with addiction, just like before we did the law with that.
And it's sort of related to this about sort of what are the conditions or diagnoses. And so in the Kuwait Criminal Act, it refers to both mental disorder as well as abnormal mental condition. And I was just wondering if you could speak to that a little bit, help us understand, what are the differences and the types of conditions upon which an NCR would be based?
Yeah. So this is the old definition, because the law was written in the 1960s. So even mental disorder was, interestingly, was defined as insanity or lunacy. So when you read it in Arabic, you find it very strange. It's not written as a mental disorder. So that's why they had to divide them into a mental disorder, into also in Arabic what they call al-ata, so which means more cognitive impairment. In reality, this is more intellectual disability or dementia. So you have to try to, when you read the Arabic, you have to try to able to differentiate between the different terms. But in the mental health law, we only made it one definition. So the mental disorder would include basically the cognitive impairment and all that. So it includes intellectual disability, dementia, and so on.
Okay, great, thank you. I think I'm going to try and sneak in one more question, if you don't mind. So this question says, so what happens if a prisoner has acute psychosis and refuses treatment, but lacks the capacity, so is incapable to consent and poses a risk?
Yeah, interesting. So it's basically the same thing as in the West. If the patient is incapable, so we deem the patient incapable under the mental health law, and in here there is, of course, the same thing. We don't have the hierarchy. For example, in Canada, there is the hierarchy where you go to. In Kuwait would be the family. But the hierarchy is present actually in a different law, in which it's ruled by the Sharia in that section. So the first would be the father, then the grandfather, then the uncle, then the mother, and so on. Or, of course, if there's the guardian who's appointed by the court. So when a doctor deems the patient incapable, they can treat them in jail. In the prison themselves, we do have a mental health facility in prison, which is actually they're working under us, under the Kuwait Center for Mental Health. If the condition is really severe to the point that the patient, for example, is suicidal and that they cannot manage him in jail, they do send him to us, to our department, the forensic department in the hospital. And we do, of course, admit them under the law now, under the mental health law, against their will, involuntarily, and we do treat them with, of course, after the approval of the RCB, and then we find the SDM, substitute decision maker, which is has to be a family member. So this is the difference. In Kuwait, it has to be a family member or someone who's appointed by court.
Thank you so much. We have so many more questions, but I'm afraid we've run out of time. Thank you for a very stimulating and interesting lecture. I'm sure I speak on everyone's behalf.
Thank you.
Very enjoyable. So that concludes today's lecture. I look forward to welcoming you back next week. Dr. Sandy Simpson will be speaking to us about recovery principles and measurement. Have a great week, everyone.
Exactly.